Can I have a reality check, too? Even if they put this witness on, I mean, how much time are we talking about? How much will it delay things?
I mean, the witness is going to take, what, 4 seconds?
Yes. This is 4 minutes.
This is going to take 96 seconds just to be.
Yes.
I mean, this is really a New York minute or whatever expression you want. This is going to be, it's basically going to be like, you've testified before that you've already said exactly how C-SPAN keeps documents. Is that true for this exhibit? Yes. But we offer it.
Is there an issue to take things out of order and to have that before the defense presents it or after the defense has started?
So the judge has offered that and said, you know, there's 2 ways we can proceed. We can adjourn now and we can take the witness tomorrow and do that. And then the state will rest and then the defense will go. Or we could just do it out of order, which happens a lot in trials where the defense starts and there's a break because a lot of times witnesses they're ill, they're scheduling, flights gets canceled, and you take a witness out of order. So he's saying, just let me know which way you want to do it, but he is giving the prosecution the opportunity to authenticate. And you know what is, I think, the principle here that is guiding this? For the judge's perspective, if not the litigant's perspective, is a trial is supposed to be a search for the truth. And here, to say that you're not going to have an opportunity to just authenticate something when everybody in that courtroom knows it's authentic, and you're going to withhold a witness coming in so that this is kept from the jury, that is not what a trial is supposed to be about. Give them the evidence that is, that meets all the rules of evidence, and then obviously the jury can assess it for what it wants. But it's supposed to be a search for the truth. This is definitely the correct ruling.
It is so telling that there is such a big fight about this, Catherine.
It's, I don't go as overboard as Lawrence. I'm just so used to defense attorneys fighting over everything. I mean, I guess they roll over in federal court. So
I guess that was a leading question. This so significant because they're having such a fight about it?
It's more corroboration for Michael Cohen. If I'm the defense attorney, I don't want him corroborated. I want to paint him as liar, 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 pants on fire. So it's very, very important to eliminate this photo. But it's not unusual. I don't that's what you should be doing as a defense attorney.
Do they roll over for you, Andrew, when you're in federal?
I would say the professional courtesies on things like this are extended both ways. But we still, both sides know how to do their job. It makes me suddenly listen to Catherine. It makes me very happy that I was practicing in federal court. I should say the other thing that I think is useful for people to understand who don't see trials, just to sort of underscore something Catherine said, which is the fact that one side or the other suddenly raises their voice or speaks in a manner that shows, conviction and how. There's a certain amount of performative aspect of this that certainly judges are immune to. They're like, in some ways it's a signal that you don't have more because, Judge Merchan's so solid. That's not going to persuade him. It's like, what's your argument?
Could it also be just as simple as a scheduling situation on their side, because now Judge Merchan is standing up on the stand with his arms crossed because the Trump team, for the first time, according to our man Adam in the court, stands up in a circle chatting with Trump, being somewhat demonstrative as they decide how they want to move forward. Blanche then walks over and crouches between Hoffinger and Steinglass. Blanche has a friendly rapport with the prosecution. Now Chris Conroy joins the conversation, and they are all looking at papers. Steinglass seems to be sketching out a schedule.